I'd like to talk to you a little bit today about the right to a public trial and what that means in our system of jurisprudence and what it means in particular in criminal cases. The Sixth Amendment to the United States Constitution, so one of the original Bill of Rights, the Sixth Amendment guarantees every person accused of a crime the right to a full, fair, and public trial. That right is further secured to the states through the 14th Amendment to the United States Constitution. It is also guaranteed to Texas citizens through the Texas Constitution and is actually codified in our Texas Code of Criminal Procedure. So clearly, the right to a public trial is a fundamental and inherent part of our system of jurisprudence and our criminal justice system. So why is the right to a public trial such an important part of our system of criminal justice? As the United States Supreme Court observed in a case called In Re Oliver, the primary purpose of public trials is to prevent the abuses that are inherent in a secret proceedings, and those secret proceedings being used as an instrument of oppression against people accused. That is a caution and a protection that our founding fathers secured to us and to all American citizens in response to what the system of jurisprudence had been in their home country of England. We all have heard of the old stories of the Star Chamber, where proceedings were conducted when lords would get together and conduct these secret proceedings, and the public and the accused would have no idea or participation or any means by which to understand what the nature of the criminal charges were, where they came from, and would have no input or insight into it, and it would just be this small group of people who would assess serious punishments, whether it be imprisonment or even execution. Our founding fathers recognized that as a threat to individual liberty, and so we have taken all these measures through the United States Constitution and our Texas Constitution, our laws, to make it an important part and a fundamental right of every criminal defendant to have a public trial. So we recognize that the right to a public trial is important. It is not, however, absolute. There are certain instances in which a court may decide to close proceedings to the public. However, the United States Supreme Court has set down strict guidelines for when and what is required before that can occur. First of all, the party that is seeking to close the proceedings has to advance an overriding interest that compels the closure. What types of things might be an overriding interest? Well, it's very fact-specific, but some of the things that you might imagine are instances where there are confidential informants involved, or where there are undercover police officers, or where there are particularly sensitive witnesses who may be placed in danger by public proceedings. So those are some of the types of circumstances where a party might ask a court to close some or all of a trial or some portion of a trial for that purpose. Advancing the interest alone, however, is not enough. The court must then consider what alternatives to closure might be available. They must also, if the court decides to close some or all of the proceedings, the closure has to be narrowly tailored. It can be no broader than what is necessary to protect that overriding interest that the party seeking closure has advanced. And then finally, the court must make findings of fact on the record that support that action to close. So even in circumstances where there may be an overriding interest for closure, the rules are very strict and very specific, and there has to be findings on the record that support that, or there will be a constitutional violation of a defendant's right to due process and could lead to a reversal of a conviction. As a practical matter, one of the areas that we're seeing this come into stark relief is the element of jury selection, voir dire. The United States Supreme Court and courts in Texas and across the country have recognized that voir dire, or the jury selection process, is part of our Sixth Amendment right to a public trial. So voir dire cannot be closed to the public either. This, as a practical matter, can be difficult at times, particularly with a number of our modern courtrooms have much smaller audience spaces. In Harris County, for example, a typical jury panel brought over for voir dire in a felony case would encompass about 60 or 65 people. That largely takes up most of the available room in the audience of the standard courtrooms in Harris County. It doesn't leave a lot of room for the public to sit and attend. And it has become a routine practice for the bailiff or the judge or some member of the court staff to clear the courtroom before bringing in the jury panel for the voir dire process. There are a number of cases that have been pending, and I will discuss one that we were involved in here recently that say that even in that instance, even when the practical considerations of the courtroom itself, there is still a right to a public trial. And if the defendant's family members, friends, or just general members of the public wish to be there, the court has to make some type of accommodation for them to be able to be present. For instance, just this past October, Parnham McWilliams represented a former Houston Police Department officer who was charged, tried, and convicted of felony theft and sentenced to 17 years in the penitentiary. We didn't represent him in trial, but we got the appeal. It became apparent during that the judge, following this kind of standard practice of Harris County of clearing the courtroom before voir dire, actually excluded several of the defendant's family members. They were told by the bailiff that they had to leave the courtroom, and they were not allowed to return. There are still places in the court to seat members of the family or just general public in the jury box or in other places in the courtroom if they wish to observe it. We took that case up on appeal, and it was reversed by the Court of Appeals based on the exclusion of the defendant's family members from the trial. The court found, indeed, that it was in fact a violation of the Sixth Amendment right to a public trial as guaranteed by the 14th Amendment. It's a violation of due process. Now, this right is so important that it doesn't even require an objection. It's not one that you can waive. A defendant doesn't even have to be aware that people have been excluded. It is sufficient that there is evidence on the record that there was an exclusion, whether the defendant knew about it or not, because the right to a public trial is constitutional, structural error that requires reversal. As a result of our case, and a number of other cases that have been coming down in the past months and years, the courts, particularly here in Harris County, are having to revise their idea and their court procedures of how they go about this voir dire process and allowing access to the public. A final note that I'd like to make on this issue of the right to a public trial is what that means with regard to a media presence. I think it's important to understand that the United States Supreme Court and courts across the country have determined that the right to a public trial really means attendance at a public trial. It does not guarantee the broader public a right to a media broadcast of the trial. So while we see that in many cases on court TV and other places where clearly there are cameras that are broadcasting all elements of the trial, if not just some, those are individual decisions by judges and the parties involved. And it is within a court's discretion to limit the access of the media. However, attendance and the right to a public trial is really what the Sixth Amendment guarantees us.